Hello, Raquel? Oh, kumusta?
Uy, kuya, okay naman. Ano balita dyan?
Mabuti naman. Raquel, gagawin sana kitang director ng Gamay Water District. Kailangan mo ba ng trabaho? Sayang naman kasi itong posisyon kung sa iba lang mapupunta eh. Alam mo na, kahit marami nagtatangkang kunin ang posisyon na ito, syempre, ibibigay ko na sa'yo ito bilang kapatid mo.
Naks, buti na lang kuya, kakatapos ko lang kasi sa isang interview. Pero parang mas maganda ata yung posisyon na binibigay mo.
May tiwala naman ako sa'yo na kayang-kaya mo to. Kailan ka ba free? Magkita tayo para sana mapag-usapan natin.
Pero kuya, ang iniisip ko lang kasi, di kaya tayo sumabit dyan. Kasi maraming mata nakatingin sa atin. Madami ding nag-aabang na mga bakante yan.
Di siguro, hindi yan. Akong bahala. Ngayon ka pa ba kakabahan?
Kaya nga, ang sa akin lang kasi, baka makaapekto to sa susunod na pagtakbo mo. Baka pag nagka-issue, makaapekto yan sa mga boboto sa'yo. Ayoko naman na ako pa maging dahilan ng pagbagsak mo.
Ano ka ba, Raquel? Sa politika, pag nakaupo ka na, wala nang gagalaw sa'yo. Tsaka ano ka ba? Wala akong kinakatakot, no? Madali lang lusutan yan kung sakali. Kung may magreklamo man, pera lang katapat niyan.
Sige, sabi mo yun kuya, may tiwala naman ako sa diskarte mo. Sige na, bye-bye.
As defined by Merriam-Webster Dictionary, condonation is the implied pardon of an offense by treating the offender as if it had not been committed. Within the legal profession, condonation is a defense argument sometimes made when an accuser has previously forgiven or chosen to ignore an act about which they are now legally complaining. In some legal jurisdictions and for certain behaviors, it may prevent the accuser from prevailing. This is what happened in the case of Domingo Crebello, who filed a complaint against Mayor Timoteo Capocchian Jr., accusing him of nepotism.
Hello? Uy pare, kamusta? Nakausap mo na ba si Raquel?
Hello pare, nakausap ko na kanina. Ipapasa ko na ang aking kapatid sa Gamay Water District. Ikaw ba? May naisip ka ba bang pwede nating ipasok dyan?
Good. Kaya nga ako napatawag eh. Kasi naisip ko, baka pwede na rin natin i-appoint yung asawa ko, si Clarita. Oo pare, si Clarita. Magkakilala na sila ni Raquel eh. Tsaka hindi rin nalalayo yung kanilang ugali at mga interests nila. For sure magkakasundo sila doon.
Wala bang plano mag-vice mayor tong si Clarita?
Kasama na yun sa plano pare. Actually, kaya ko nga gusto sanang i-appoint siya as one of the members ng board of directors ay para maging training ground na rin niya. Para ba masanay siya sa pressure ng trabaho at para maging maayos din yung pagharap niya sa mga tao.
Abay, ipapaalam ko agad sa sekretary ko yan. Maraming gustong makakuha ng posisyon na yon. Siguro sa Lunes, next week, maaari na silang magsimula agad. Sayang naman kasi yung posisyon dito sa ating bayan kung di natin gagamitin para sa kanila, no?
Okay, sige. Good. Balitaan mo na lang ako. Sige. Salamat pare.
Domingo Cabello, a member of Sangguniang Bayan raised from Partido Federal ng Pilipinas Party, filed a complaint against Mayor Timoteo Capocchian Jr. and Vice Mayor Enrique Gomba for nepotism. By order of June 9, 2014, the office directed respondents to file their counter-affidavits. Complainant was likewise given the chance to file its reply thereto. By order of January 13, 2015, the office directed the parties to file their respective verified position papers.
Akala ko ba walang sabit tong pagkaka-appoint sa amin ni Clarita? Cribelli just filed a case against us.
It was all over social media. Nasa website ng Inquirer, abogado.com, and even sa Scribd. People are bashing us already. Paano pa ako tatakbong vice mayor niyan?
Kumalma kayo. Hindi maaaring gawin ni Carbelio yan.
But he just did! My God! After all my sacrifices, napaka-ungrateful naman niya.
Attorney, anong pwede nating gawin? The court is demanding na mag-file tayo ng counter affidavit. They're directing us to file our respective position papers.
Calm down. We need to plan our moves with precaution and decide our best course of action. No need to panic. Hindi sila basta-basta mananalo sa kaso. They need enough evidence, and even with enough evidence, the case may still be dismissed by the ombudsman.
Sige, what steps do you have to take to make sure that they don't get the upper hand? We don't even know what evidence they currently have or what evidence they will use against us.
If they do have enough evidence, paano na po kami, attorney?
Mayor Kapokyan, you do not have to worry. You have been re-elected during the 2010 elections, which means that the administrative case against you must be dismissed by virtue of the condonation doctrine. However, that is not the same case for you, Vice Mayor Gomba.
Ano na kami niya ni Clarita? Hindi ako pwedeng matanggal sa pwesto. Attorney, maraming nakasalalay sa mga plano namin. Hindi kami pwedeng i-dismiss.
Calm down, Vice Mayor. I strongly believe that this case will be dismissed by the Ombudsman, so hindi niyo po kailangang magalala. There is still a need to examine the evidence presented by Carbelio to determine if the same is sufficient to indict you of the crimes charged. The case will thus be resolved on the basis of the evidence on record.
Your Honor, and ladies and gentlemen of the jury, the defendant has been charged with the crime of nepotism. The evidence will show that the appointment of Raquel on March 5, 2008 is nepotic, as she is related to respondent Kapokyan Jr. within the prohibited third degree of consanguinity, and that the appointment of Clarita was also nepotic, for she was recommended by her husband, respondent Gomba, as vice mayor and presiding officer of the SB. The evidence that I present will prove to you that the defendant is guilty as charged.
Your Honor, ladies and gentlemen of the jury, under the law, my clients are presumed innocent until proven guilty. During this trial, you will hear no real evidence against my clients. You will come to know the truth that Timoteo Capocyan Jr. and Enrique Gomba did not appoint Raquel Capocyan and Clarita Gomba. Rather, it was a mere accusation by the complainant out of envy and dissatisfaction, which is not tolerated by the law. Raquel Capocyan and Clarita Gomba were elected as members of the boards of directors following due process. Therefore, my clients are not guilty.
Respondents, however, failed to heed both activities. Such failure is taken as a waiver on their part to contest the charges. In its decision, the Office of the Ombudsman held that by reason of the re-election of respondent Kapokyan Jr. as mayor during 2010 elections, the administrative case against him should be dismissed by virtue of the doctrine of condonation of administrative offenses committed during prior term following the court's ruling in Aguinaldo v. Santos. However, that is not the case for Vice Mayor Enrique Gomba.
Charge against respondent Timoteo T. Capocyan Jr., who was re-elected as the mayor of Gamay, Northern Samar, is hereby dismissed by reason of the re-election of respondent Capocyan Jr. as mayor during the 2010 elections. The administrative case against him should be dismissed by virtue of doctrine of condonation of administrative offenses committed during a prior term. Respondent Enrique C. Gomba is hereby found guilty of nepotism and meted the penalty of dismissal from service. The penalty of dismissal shall carry with it cancellation of eligibility, forfeiture of retirement benefits, perpetual disqualification from holding public office, and bar from taking the civil service examinations.
Good day. We would like to request for further investigation and partial reconsideration for the doctrine of condonation.
The said doctrine has already been abandoned on November 10, 2015 through the ruling of promulgated in Morales v. Court of Appeals. Hence, the doctrine could no longer be applied in favor of Respondent Capocchian Jr.
The ruling in Morales versus Court of Appeals became final only on April 12, 2016. The date of the promulgation of the minute resolution denying with the finality its motion for clarification or motion for reconsideration. Stated in Circular Number 17 on May 11, 2016, cutoff date on the condonation doctrine, and to the state that the Ombudsman would no longer implement the condonation of doctrine from April 12, 2016 and onwards.
Aggrieved, the petitioner assailed the resolution of the Ombudsman in the Court of Appeals by petition for certiorari, alleging that the Ombudsman thereby committed grave abuse of discretion, amounting to lack or excess of jurisdiction. However, the Court of Appeals promulgated the assailed resolution of January 16, 2017, dismissing the petition for certiorari for being the wrong legal remedy on the basis of the pronouncement made in Fabian B. Desierta 7 to the effect that appeals from the decisions of the Ombudsman in administrative disciplinary cases should be brought to the Court of Appeals to petition review under Rule 43.8. The Court of Appeals denied the petitioner's motion for reconsideration on June 14, 2017.
In this appeal, two issues are presented for consideration and resolution, namely, 1. Whether or not the CA erred in holding that the petition for certiorari was the wrong remedy to assail the decision of the OMB absolving Respondent Capocchian Jr. from the administrative charge of nepotism, and 2. Whether or not the OMB committed grave abuse of discretion in applying the condonation doctrine in favor of Respondent Capocchian Jr.
We have ruled in Fabian v. Desierto that, indeed, appeals from the decision of the Ombudsman rendered in administrative disciplinary cases should be taken to the CA via petition for review under Rule 4.3 of the Rules of Court. We have reiterated this ruling subsequently.
With the absolution of Respondent Capocchian Jr. being already final and no longer appealable, Rule 43, which defines a mode of appeal, obviously did not apply. Therein lay the reversible error of the CA. We go further. The petitioner was not bereft of a recourse or legal remedy against the absolution of Respondent Capocchian Jr. The final and appealable decision of the OMB could still be the subject of judicial review through the petition for certiorari upon allegation and proof of grave abuse of discretion on the part of the OMB.
In view of the foregoing, we find and hold to be correct the petitioner's stance that the resolution absolving Respondent Capocchian Jr. of the charge of nepotism, being final and unappealable, could still be challenged or assailed through the petition for certiorari, and plainly enough, the CA wrongly dismissed the petition for certiorari for being the wrong remedy on the notion that the decisions of the Ombudsman in administrative cases should be assailed before the CA by petition for review under Rule 4.3.
The Ombudsman claims that the Court of Appeals' consideration of condonation concept was inappropriate because it was a defense that should have been discussed and decided by her office during the administrative disciplinary processes. Condonation is an affirmative fact that the respondent must raise in the administrative processes in order for the Ombudsman to fully evaluate and rule on the issue. In the case of the respondent Capocchian, this did not occur. With this, Respondent Kapokyan Jr. should now be held administratively accountable for nepotism, which the Ombudsman deemed to be fully established against him, and he should be punished by being dismissed from the service with all the consequences. However, because the alleged crime occurred during his term as municipal mayor of Municipality of Gama in the province of Northern Samar, which ended in 2010, the penalty of dismissal from the service can no longer be applied to him, but he should face several secondary penalties.
The reliance on the condonation doctrine is a matter of defense. It is inappropriate for the Court of Appeals to have considered it, which should have been raised and passed upon her office during the administrative disciplinary proceedings.
Your Honor, and ladies and gentlemen of the jury, condonation is an affirmative fact that the respondent must raise in an administrative processes in order for the OMB to fully evaluate and rule on the issue. That was not the case with respondent Kapokyan Jr., whose refusal to file or submit his counter affidavit and verified position paper despite notice made it clear that he had not brought the doctrine of condemnation or any other defense before the OMB. By condoning respondent Kapokyan Jr., the OMB clearly behaved arbitrarily.
Respondent Kapokyan Jr. should now be held administratively liable for nepotism, despite the principal penalty of dismissal becoming moot. He should nonetheless suffer the accessory penalties of cancellation of eligibility, forfeiture of retirement benefits, perpetual disqualification from holding office, and bar from taking civil service examinations. Otherwise, the law becomes a travesty.
Hello, Raquel? Oh, kumusta?